Welcome to this ordinary meeting of the Wingecarribee Local Planning Panel, today 27th of August 2025. I declare the meeting open at 2:02 p.m. Wingecarribee Shire Council acknowledges the Gundungurra and Tharawal peoples as the traditional custodians of this land we now call the Wingecarribee Shire. I pay my respect to Elders past, present and emerging. I would like also to extend that respect to all Aboriginal and Torres Strait Islanders present here today. My name is Stephen Lehman and I'm the chair of today's panel. Also sitting on the panel today are expert members Heather Wharton and John McFadden to my left, along with community member Richard Colley to my right. The meeting is being live streamed to Council's website and the recording will be made available on the website after the meeting. At this stage, could I ask everybody to check their mobile phones and turn them to silent or off as appropriate. For today's meeting, there are no apologies. We have a full complement on the panel today. I might just ask the panel members to confirm that no late matters have arisen that would suggest that there's any conflict of interest. Panel members, no further?
I have no conflict.
Conflict of interest?
I have no conflicts of interest.
Thank you. So as no declarations have been declared, we'll proceed with the meeting. The website contains a copy of the operational guidelines for panel meetings, but I will summarise the most important points. The panel is charged with considering one planning proposal, item 5.1, and three public matters, development applications, items 6.1, 6.2, and 6.3 on the agenda today. I have 4 registered speakers. As per the operational procedures, public members addressing the panel are given a 3-minute time limit at the discretion of the council. Council may have questions to ask, so I ask at the end of your address that you remain seated until we see if there are any questions or comments for you. So after we've heard the speakers, we will deliberate and return to the public meeting to announce our determinations, and that will be live streamed. The minutes of the meeting should be placed on the Council's website within 2 business days. I'll now call the speakers. Item 6.1 is DA 25/0864. It is for the demolition of an existing commercial building and construction of a mixed-use building comprising ground floor retail space, upper level office space and on-site car parking level and an on-site car parking level at 28 Station Street, Bowral. Speaking for the proposal, I have Scott Lee. Come forward, please, Mr. Lee. Introduce yourself and just explain your relationship to the item.
Yeah, thank you, Chair. Scott Lee is my name. Consultant planner acting on behalf and speaking on behalf this afternoon of the property owner and applicant.
Thank you.
Thank you. Panel members, obviously my client's disappointed in the recommendation that's before you this afternoon. I've been requested to speak briefly and request that rather than being a refusal this afternoon, the panel consider deferring this matter. The report obviously provides quite a long list of reasons for refusal, but there's just a couple of issues I'd like to touch on which supports our request for deferral. They're associated. One is the owner's authorisation matter, which we did seek authorisation from the council, and the council did issue that. I think from reading the report, it appears that that's been issued in error with the omission of one property, which I think is lot 3. Forgive me, I don't have the DP number, but that's mentioned in the report. So the council did issue owner's authorisation, but seems like it was incomplete, if I'm reading the report correctly. I would have thought that that would have been something that the council could have rectified quite simply, rather than put it as a reason for refusal. Associated with that is the broader issue of access across council's car park. The report indicates that there is informal agreement for that. We don't see it as an informal agreement or an informal arrangement. Been made quite clear to council on numerous occasions, because this is the second DA, that the existing access across council's car park to the subject property or to the rear of the subject property was granted by council in a development approval some 40 years ago, which included agreements between council and the property owner for the use of some of the car park, access across the car park to the site, and indeed the dedication of part of the property at the time, free of charge, to the council to improve the efficiency of the car park. To imply that there is an informal arrangement for access across the car park, we don't believe is fair and reasonable. We believe we have lawful access across the car park, notwithstanding the fact that there is no registered easement. But for 40 odd years, we've had access across the car park. I think those two reasons, I think, are fundamental, certainly this issue of access, and that supports our request for a deferral rather than a refusal. That the issue is associated, I also believe, with a more recent adoption of a property-related policy of council for how they would deal with access across their own lands, including car parks. And we were not aware of that until very recently, and we were under the impression that after a meeting with the council property people and members of council's planning division, that we would be given a brief explanation of the policy and then be offered an opportunity, if we took it up, to perhaps withdraw the application, because the implications of the policy, as it was explained to us, were that access across council's car park would not be forthcoming. That's a decision ultimately for council, but it's not a matter that we've had any chance to properly consider. Rather than getting that letter that we were expecting, we got notice of this meeting. So without going into all the other reasons, planning-related reasons.
Time's up, yes. Just if you can wind up.
Yep, that's it. So really, yeah, I'm just asking the panel to consider a deferral rather than a refusal to allow us and council to discuss the property-related matters that are pertinent to the issue.
Okay, I might just ask the panel if they have any questions for you or comments.
Yes, thanks, Mr. Lee. How are you proposing to fix, as it were, you just explained there's historical access rights, as you have explained. How are you proposing that that would get fixed to a formal right?
Through the pre-DA discussion, the question of formalising rights across council's car park in favour of this property was mentioned as an issue to be resolved, and I had commenced that process in April of this year, seeking some input from council's property team, as distinct from dealing with the DA team, to commence that process of securing an agreement to create that right of carriageway. It was, I was under the impression that was proceeding until we were notified that there was an issue associated with that, and that's when we attended the meeting a couple of weeks ago, and that's when the council's new policy, which I can't say I know all about, seems to have had some impact on that proceeding. So that's our intention, was that it would be dealt with by the creation of a right of carriageway, but that hasn't been possible up till now.
Any other questions?
Mr. Lee, you mentioned that authorisation from council was issued in error. I gather
It
that's
appears to be issued in there.
Appears to be,
There was issued, but there's one property missing.
okay. And from what you've just described with the previous question, those negotiations with property were ongoing. They weren't necessarily resolved ahead of submission of the DA.
The negotiations for the right of carriageway. We sought owner's authorisation to lodge the DA and provided some background information. And this, don't forget, this is the second time round. This was done previously. But for this DA, I sought owner's authorisation from the council's property team, provided the information to them in relation to the current arrangement for access, which really relates to the 1982 DA. And on that basis, the property team issued the landowner's authorisation signed by the general manager, but on inspection, and was unknown to me, or any of us really, I think the assessment report prepared has picked up the fact that there is one lot that was not nominated on that form, and that's been seen now as a problem. Fair enough, needs to be resolved. But that's what I said earlier. I would have thought that that was something that council could have easily resolved rather than it ending up as a reason for refusal. But there's one lot that was omitted from the signed authorisation.
Thank you.
Are there any other questions?
And it's really just further on. You've referred to this one lot a number of times. Is that the access to 26 Railway?
Well, I suppose it forms part of the car park. The lot in question that was omitted from the landowner's authorisation form from council is only a very small sliver of land that immediately abuts the subject site and the existing building on our site. That small lot, lot 3, was dedicated to council as part of the approval of the 1982 DA when the agreement with council was granted to access the car park.
So
That's my understanding of the lot that is missing from council's authorisation. It's not fundamental to the vehicle movement through the car park, but it is fundamental to the car parking spaces that immediately abut the existing building on our site. And that's why council sought to secure that bit of land in the 1982 consent.
So, sorry, is that the little rectangular car park at the back of 26?
It's on the side, it's on the northern side of 28, the subject side. Immediately adjoins 28 Station Street, the development site. It's a small, I think it's a rectangle, I think it's a triangular shape. It's an odd shape, but it's long and narrow down the side of the building. It was originally part of 28. Council saw utility in, I say acquiring it, but it was given it, dedicated by the owner as part of the DA, because that made the car park more efficient. Okay. We're not disputing that, it's just that that's the missing piece from owner's authorisation point of view. It's part of the history of access that this site, our site, enjoys across council's car park. And when the report says there's an informal arrangement for access, I simply say that it's not informal, it's formal, it's lawful, it's not covered by a right of carriageway, but doesn't mean that it's informal and it doesn't mean that it's unlawful.
Okay, thank you.
Is there another question? Supplementary?
Yeah, thank you. We understand, well, I understand better, I know you've explained that background to the rights of access. There are other reasons for refusal, such as the floor-to-ceiling heights and whether that's suitable for retail premises and the number of stories that you're proposing compared to what would otherwise be expected. Have you got any, because they're real reasons for refusal, not just something that could be cured by conditions or so on.
Oh, well, at this point, I haven't turned my mind greatly to all of those other reasons. It's a design-related response, I suppose. The building is compliant in terms of the development standards. How you fit your building into those standards is the question as to whether or not it's suitably designed. And like I said, I really haven't turned my mind to that. There's a number of reasons for refusal that are, certainly reasonable from a council's perspective to put forward, I would have thought. Whether or not they're insurmountable, that's a different question. Whether or not, with more opportunity to engage on those matters, can there be a resolution? You'd think so. So I wouldn't say that they're, I wouldn't dismiss them as reasons but I would say that we haven't had the opportunity to properly discuss them and discuss solutions with the council over the period of the assessment. We did have council did issue a request for further information, which was responded to, but there hasn't been any of the, opportunity to really sit down and nut it out with the council officers about what a good solution to those issues looks like.
I note, Mr. Lee, that this application's been with the council since December 2024. Council's obliged to determine these promptly. There may be other remedies or pathways to deal with the matters you're raising. I think it's going to take time, so that's my concern. I won't say any more than that at this point.
Oh, that's not a question, is it?
Unless you'd like to suggest an alternative, address those concerns.
No, I didn't arrive this afternoon with solutions to the majority of those reasons for refusal. Yes, it's been in for a long time, and I appreciate the panel's under just as much pressure as council to make decisions as distinct from deferrals. But the point I'm making is that one of the key issues here is property related and access, and that has not been my client has not been given any fair or reasonable opportunity to discuss that. And that's important.
We've got that. Thank you. Thanks very much. No more questions. If there's no more questions, I'll release Mr. Lee from the chair. We'll move on to the second item, item 6.2. It's DA 25/1204, demolition of existing dwelling and associated structures, civil works, landscaping and the Torrens Title subdivision to create 5 lots at 26 Berrima Road, 15 Maurice Court, 17 Maurice Court and 18 Maurice Court at Mossvale. I have 2 speakers. Firstly, against the proposal, Gordon Faithful. Is Gordon Faithful here? And we've received copies of a PowerPoint presentation, Mr. Faithful, from you. 1 copy, so we've circulated that amongst the panel. First of all, then, can you introduce yourself and tell us your interest in this application?
George Faithful is my name. I am a resident of 28 Berrima Road, Mossvale, my wife Karen and I. We moved there last October, and we are neighbours, or the back part of our property, neighbours onto 26 Berrima Road. Certainly. Is there a possibility of putting up the... Great. I didn't forward... There we are. Okay, this has turned out to be a PDF, so I hope that's okay if I say next, please. All right, this is... I think everyone's fairly familiar with the overhead view. In blue is 26 Berrima Road property. Our property is highlighted in yellow there. As you can see, it fronts onto Berrima Road, a very busy road, and the back of it is next to where most of the property is going to be developed, and there is a driveway beside that as part of the battle axe. If I have the next picture. Just to give a quick view, it's a lovely property, landscaped, and it has a front fence which shields Berrima Road's traffic there. It's right down the road from a cement works, from the recycling centre. There must be about 100 trucks every hour going past there, very noisy. We have gates, a fence and the trees that you can see growing there on the right-hand picture, including, apart from the dark green trees, there's a light green tree next to it. Next slide, please. There's a picture of just one typical such truck going by, and that's one of the smaller ones. And the second picture shows the side battle axe driveway and our house to the right there. Next, please. That's the front. As you can see, again, that green tree I pointed out is right in the middle there. The next picture shows further down past that the fence going onto the driveway. Next picture. Then that continues down to the bottom there. Then there's a right angle. That follows on the right-hand picture of the back fence, which borders on to where most of the 5 properties are going to be. Next picture. That continues along and then finally culminates on the right-hand picture there in a right angle and just part number 30, which is a neighbour, not to do with our property. So having borne that in mind, if we can have the next one, this is the issue that I want to talk about. The arborist has declared that, well, the original thing was trees 43, 45, 46 should, the 3 green ones would remain and the trees in yellow would be removed. I want to talk about trees 1 and 2 and trees 45 and 46. Next picture, please. Again, on the left-hand side, you can see that lighter green tree in the middle is tree 1. Behind it, the spiky bits, which is what happens in winter, is tree 2. The second picture shows tree 2 in summer, and you can see it's a much more developed tree. And finally, the right-hand picture is a picture of where the road is finally exposed at the end of that tree. Can I have the next one, please? Again, you can see the traffic there. I have highlighted an example. I didn't get a cement truck, but that's usually what they are. They're usually a lot higher than what I've circled there, but that's where we finally see the traffic and where the noise starts to come out into our property. Next, please. This is the diagram that's provided. It's somewhat limiting in its actual visual because it appears to be completely parallel. If you look at the next picture, we can see that it's not parallel indeed. In fact, the trees there's a lot wider. You can see from the yellow and the orange. So the driveway, in fact, is a lot wider. Next picture. And then one more picture. Okay, you can see that the tree 1 is right next to the fence. Tree 2 is the thing that's blocking the driveway of the property. So tree 1 has very little to do with that. Last picture. Thank you. So you can see that if that green tree gets removed, we will be far more exposed to noise pollution and to visual and privacy issues. So I want to remove tree 2, fine, but keep tree 1. Last but not least, I've run out of time, but I want to maintain all 43, 45 and 46. They're again hugging the property. I see little need to remove those because they don't seem to be in the road at all. And I'll finish my presentation there.
Thank you. Before you leave, any questions from the panel?
Sorry, just so I'm clear. So tree 1, like the variegated Pittosporum tree, that's the one you want to retain?
Yes,
And then tree 2 was the conifer?
I imagine so.
It looks like a conifer.
Yeah,
Yeah.
it's the one that actually sits in the way in
Yeah.
the driveway. Tree 1 is pretty much hugging that. You can see it makes a big difference to us, but it would make very little difference, I believe, to the property. It says that they will be removed and a garden bed would be placed in instead, which
Right.
of course will not serve the purpose that we need.
So we should check out the reasons why tree 1 has to be removed and if there's any reason why it can stay.
Absolutely.
That's what you're asking us to consider?
I'm also asking for tree 46. There was a
Yep.
change in the arborists. 43 and 44 are going to
Yeah.
be maintained. It originally said 45 would, it now says no. I'd like to maintain 45 and 46 because that retains our privacy.
Okay, and you're
from
saying you're understanding that 45 and 46 are proposed to be removed? at the
Apparently,
moment?
yes. and
Okay,
I-
so we're talking about tree 1, 45 and 46
That's
to
exactly
consider.
correct.
Okay, thank you.
That's all I'm looking for. I
Okay.
don't object otherwise.
Thanks very much.
Thank you.
Any further questions from Mr. Reid?
Mr Faithfull, you've indicated exposure to noise and privacy as your main concerns. May I just clarify? given that you've shown photographs of trucks on the actual road, is it noise and exposure to traffic on Berrima Road and not necessarily the traffic in the driveway of the actual development that you're concerned about?
That's correct.
Thank you.
Any other questions? I would like to ask the consultant planner who's prepared this report to respond if he can, or as much as he can, in respect of the tree retentions that you're seeking. Tree 1, 345 and 346, correct?
Correct.
Are you in a position, Mr. Swan, to respond into one or all of those?
I can answer the majority of those questions.
Yeah.
So in respect of trees 43, 44, 45 and 46, there's a condition of consent which is condition 4A, which talks about the removal of the trees, and then condition 4B then is about retention. So trees 43 and 44 in the amended scheme are retained. 45 and 46 are removed.
Understood. Do we have the reasons for the removal of those two and retention of the other two? Removal of 45 and 46 and retention of the others? If not, if you can't answer that, we'll make inquiries after this meeting.
I need to have a look at the Arborist report
I'd like to
specifically.
understand why some and not all.
Yep. And in
retained.
respect of trees 1 and 2, again, the same thing. I'd have to have a look at the Arborist report again.
Okay, thank you. We'll look into that in our deliberations. Thanks very much. I think that's all. Thanks for your submission. We do have, speaking for the proposal, Paul Bradnon. Is that a correct pronunciation? Bradnon? Mr. Bradnon? Thank you. Just introduce yourself and tell us your interest in the matter, please.
Good afternoon, Chair. I am Paul Brandon.
Brandon.
I am the developer's representative. I am a registered surveyor and BPAT accredited bushfire consultant and have been involved with the project since its inception. I note and acknowledge and thank the neighbours for their contribution and also the panel today for their time and consideration on the matter. I wanted to just raise a couple of brief points to summarise our application here, which seems to be largely in concurrence with Council's team of planners and assessors, etc., who have worked so hard over the last 18 months to make this project work. I should acknowledge that the alignment of Council's assessment and recommendations. So Council has already recommended the approval of this through a thorough assessment of planning, environmental and engineering considerations. We have listened to neighbouring properties and taken in their thoughts and comments into our planning. The application is consistent with the Wingecarribee LEP and relevant subsections of the DCP. Sensitive environmental and tree management issues. We've engaged a qualified project arborist to oversee tree protection in accordance with Australian standards. This is an opportunity to remove some weed species or exotic species and replace them with suitable native vegetation and improve the long-term biodiversity outcomes. We have provided a landscape plan which does take into consideration the loss of some trees and the replacement of natives. I do note and acknowledge the neighbours' comments regarding the removal of certain trees. I don't think those comments necessarily reflect the replacement of those trees with native trees. So I do appreciate the noise loss, but we have actually listened to that and counted that with the landscaping. Furthermore, I note at the southwest corner of the neighbour's property, there had been a couple of trees flagged for removal, and that had been to insert stormwater assets into that area. For quite some time, the subject land has been affected by some stormwater overland flow, which has had a detrimental impact on the on the subject land, and part of the engineering design for this proposal has been to address those matters. That has-
Sorry for interrupting you. You're talking about trees 45 and 46, is that right?
I don't have the diagram in front of me to quote the tree numbers,
Sounds
but
like
I
it.
believe they are those trees, yes.
Okay, thank you.
So it's not that we're looking to do mass tree clearing, and as the landscape plan shows, we're happy to replace trees. We're happy to listen to the neighbours and work with them and plant some natives in there to make sure that we're retaining a green and environmentally sensitive outcome for the community. Just move on to infrastructure and servicing standards. Yep, okay, so looking to manage stormwater, and that has been a crucial part of this application. The property slopes towards the west and has traditionally drained by overland flow through to a drainage reserve in adjoining lands. Stormwater assets in those three lots in question in Maurice Court had been undersized and completely choked and not in good maintenance at all. A review of those assets has found that it would be a benefit to all of the neighbours to upgrade those assets to a larger size pipe and to new pits and head wall, and which drain into council's drainage reserve, which is the whole reason why this application has been sent to the planning panel, because council felt that because we're replacing the head wall in the drainage reserve, then it should come to the planning panel rather than council assessing this in-house.
Okay, I think we've got an understanding of your issues, unless there's anything you particularly want to put to us. We'll see if there's any questions. Is that okay?
Yep.
Any questions, panel?
So I gather you're okay with the conditions of consent, or you've read the report?
I think it's largely fair and balanced, yes.
Okay, thank you.
Any other questions? So there's no further questions. Thank you for your submission.
Thank you, Chair, and thank you, panel.
Thank you. Next item is item 6.3, development application 25/0258, demolition of existing dwelling garage and sheds and construction of 4 single-storey independent seniors living units, landscaping and associated works at 28 Purcell Street and 12 to 26 Derby Street, Bowral. Speaking for the proposal, I have Adam Piper and Sunil Manilal. So would one of you, a suitable person, come forward? Sure. Introduce yourself, please. Tell us your interest in the matter and give us your...
My name's Adam Piper. I'm a consultant town planner that's part of the design team that prepared and lodged the development application for council. Thank you for the opportunity to talk to you today. Our application seems to have very similar or parallel issues to item 1 on the agenda today. I too seek that the panel defer their decision on the basis that we've remained in this application for an extended period of time and always sought to consult and promptly provide information to council to address any concerns. As an example, we could have pursued a deemed refusal pathway and taken this matter to court rather than continuing the debate or the discussion constructively with council, which we've sought to do the whole way. If the panel determines the application today by way of refusal, we'd be faced with the prospect of going to court, spending a large amount of council's money, but also my client's money, and we don't really want to do that. And nothing that we've indicated through the application process indicates a combative or objectionable approach. We have sought to conciliate and we want to continue to do that. From our perspective, the issues that have been raised are matters that we can simply address or clarify, or we believe we already have clarified. Obviously, council's not of the same opinion, but those things often are simply resolved by sitting across the table with the relevant experts and thrashing them out promptly and constructively rather than pushing this application to refusal. So much like the first item today, we'd encourage you to do that if possible. As an example, I believe, a 4-week period would be sufficient for us to consult with council and resolve the issues.
So I understand you must be alluding to the stormwater easement issue or the need to connect into council's reserve. That's part of the issue that part of the issues that you're raising?
Yeah, look, that's one of the issues, and certainly we consulted extensively at the outset with council's property section, and what we provided we believed was adequate. But I noticed that it's one of the first items on the refusal recommendation is what I understood of the comment was that at no point was it clarified whether it was permissible to drain into the RE1 zone. Now, from a planning perspective, drainage in the RE1 zone is a permissible form of development. So that's a relatively straightforward matter that's resolved through reviewing council zoning provisions, if that's the issue. But it's an interesting point that I read the reasons for refusal and understand them a certain way, and it may be that in the RFIs that have been expressed by council, the design team might not have fully understood what was being requested, but we certainly responded promptly and utilised all relevant experts in responding to council. So if there's concerns that remain that have been there the whole way through, which from our perspective we don't believe that they have, but if those concerns are still there, they're simple things that are resolved through open communication.
Okay, and similar to the first one, I guess, is there were other reasons for refusal besides stormwater easement and the technicalities maybe of that, such as the narrowness of the access.
Yeah. So
That how would deferral help you with that?
the last response that was provided by the architect to council incorporated a modification in the design to provide a dedicated path of travel for pedestrians adjoining the driveway. The driveway does narrow at the front of the site, but we've had expert traffic engineering advice the whole way from PDC Consulting, and from what that expert is telling us, the driveway operates effectively. So in my mind, that's a situation where council's engineers might not agree with our consultants, but that isn't being expressed to us in a way that we readily interpret and understand. You've been given reasons for refusal, but I'm sure that if the two engineers sat opposite in a table, which is what will happen when we get to conciliation, why not do that beforehand? We want to do that. And we can do it without spending anyone's money and get them across the table and solve the problem. But, you know, when I'm relying on the advice of an expert that's been appointed to the job and he's saying it's okay, well, you know, who am I to argue with him, really?
Are there any other comments or questions?
Thank you, Mr Chair. Mr Piper, you mentioned that the driveway narrows. At the very commencement of the site, at the frontage, if you like, have your traffic experts indicated that there is the option for separation between seniors, as in pedestrians, and vehicles at that point, or is there likely to be a conflict in that location?
Could I clarify the question? Do you mean entering into our site or?
Yeah, so the driveway,
Yeah.
so it's a seniors living development.
Yeah, so we've got four houses, which is a fairly low density development. It's a gated development, so the vehicles and the pedestrians stop at the entry to gain access to the site. The seniors living guidelines and standards, as well as the Australian standards that apply to trafficable access, don't require them to be separated. Now, I use the analogy in discussions with the team. If you rationalise the movement of vehicles into a four-dwelling house development in a gated community, it's a low-speed, low-volume scenario. There's no overbearing risk in my mind, but if you use the comparison to, say, a shopping centre where you've got hundreds, if not thousands, of vehicle movements in a constrained environment. Even within those environments, this standard recognises that the safety risk because of the low speed movement is such that it's not necessary to have a separate designated path of travel for pedestrians. So it's my understanding of the advice that that there isn't a need to have a entirely separate path for pedestrians to come through, and that's on the basis of the speed and the volume of movements into the site.
Thank you. So I think you've answered that question in that it's not shared. Just out of interest, the location of the bins, when they are placed on the curbside, would you be able to confirm they'll be in front of the adjoining property? Is that correct?
I'm not sure.
So
I don't know.
So in terms of your frontage, there's inadequate frontage for any bins to be lined up on the curb?
Beyond the width of the driveway,
That's right.
that would probably be the case, yeah. In terms of that, what we would normally do is either have a contractual service, or some councils offer services where, I know for larger multi-dwelling house developments, we locate bin servicing or bin standing areas on site, and a lot of councils will offer a contractual service with a runner. So say you've got 20 homes, for example, and often those don't have sufficient frontage to present the bins. We allocate a designated bin storage area, and it's a contractual arrangement managed through the strata, which would be the same in this situation, would be probably the most practicable and safe solution to that situation. But it's not a showstopper, and much like a lot of these other issues that are raised, the way I read them, they're issues that have solutions that could readily be put forward, and we'd like the opportunity to do that.
Thank you.
Any further questions? I just comment that the court is not your only recourse. If we do decide not to defer this application, you've got review ability, 8.2 of the Act, and you know, if you say you can do all this in 4 weeks, then you would comfortably fit within the time frame for that. You would at least have clarity on what the issues are.
Yeah, look, that's an entirely valid point.
And so, you know, I note that this has been in since October 2024. It's a long time, and we're obliged by our masters, by the Minister, to reduce our determination times, and it may be that that's a more effective way of dealing with it.
I acknowledge that, and look, it's a
like,
fair point. I would invite the panel to review the history of the application if you think that that's a pertinent point. At all points, we've responded quite quickly to council's RFIs, and look, personally, I don't feel that was necessarily the case on council's behalf, but I understand there's pressure from state government and recognise that, and that's why I say, well, you know, practicably, I would see the consultation or conciliation is the quickest way to resolve it. Just in the back of my mind, I'm not 100% sure whether this one was integrated. It used to be that there was a Sydney Water referral, but I think the Act might have been changed. But if we are, just verify that. If it's not the case, then yeah, we do have the review mechanism, but if it is integrated, we don't. There's no bushfire affectation on it, so it's not integrated from that perspective, but there was a water referral at one point in time that applied, but
we can
anyway,
make inquiries about
point
that.
taken.
We can make inquiries
Yep.
about that. All right, thank you. I think that's all. Thanks very much. The speakers have now finished, and that concludes the public part of this meeting. Yes. No, Sunil, did you want to speak as well? Yeah, the previous speaker was speaking on your behalf. Yeah, that's what I thought. Sorry. Thanks for confirming. Thank you. Yeah. So that being the case, that concludes the public part of this meeting at 3:47 p.m. As previously indicated, we will now retire to deliberate and return to the public meeting to announce our decisions. This will be live streamed, and the minutes of this meeting will be placed on the council website within 2 business days. So I thank you for your attendance. I'll declare the meeting, as I say, closed at 3:47 p.m. This is the announcement of decisions of the local planning panel held in council chambers at Wingecarribee Shire Council Civic Centre on Wednesday, 27th of August 2025. In relation to item 5.1, planning proposal to rezone a portion of the Southern Highlands Innovation Park from E4 General Industrial to E3 Productivity Support in alignment with the adopted SHIP Master Plan, the panel advice is that the panel supports in principle the rezoning of the land to encourage creative industries as a gateway to the Southern Highlands Innovation Park. However, the panel considers that it is premature to make a gateway determination submission in accordance with section 3.34 of the Environmental Planning Act. The detailed reasons for the panel's advice will be given in full in the published minutes on Council's website. In relation to item 6.1, DA 2.5/0864, demolition of existing commercial building and construction of a mixed-use building comprising ground floor retail space, upper level office space and an on-site car parking level at 28 Station Street, Bowral. The panel determines development application DA 25/0864 by way of refusal, subject to the reasons specified in the officer's report, with the following amendment to Condition 4. Condition 4, owner's consent has not been submitted to facilitate, sorry, it's not Condition 4, that should be reasons for refusal 4. Owner's consent has not been submitted to facilitate works over all of the affected allotments, and there is no evidence of any encumbrance on the adjoining council property title benefiting the subject site. Panel's further reasons will be given in the published minutes. Item 6.2, DA 25/1204, demolition of existing dwelling and associated structures, civil works, landscaping and Torrens Title subdivision to create 5 lots at 26 Berrima Road, 15 Maurice Court, 17 Maurice Court and 18 Maurice Court, Mossvale. The panel determines development application 25/1204 by way of approval, subject to the recommended conditions of consent detailed in the officer's report, with amendments to conditions 56 and 57 requiring council to be nominated as the authority empowered to modify, vary or release the terms of the encumbrance. Full details of those conditions will be published on the website. That concludes, I beg your pardon, 6.3. Item 6.3, DA 25/0258, demolition of existing dwelling, garage and sheds and construction of 4 single-storey independent seniors living units, landscaping and associated works at 28 Purcell Street and 12 to 26 Derby Street, Bowral. The panel determines development application 25/0258 by way of refusal, subject to the reasons specified in the officer's report, with the following amendment. Reason for refusal number 1, insufficient information has been submitted with the application to demonstrate the works within the adjoining RE1 public recreation zone land, brackets Stephen Park at 12 to 26 Derby Street, Bowral, benefit from adequate arrangements to make available stormwater infrastructure that is essential to the proposed development. Panel's reasons are further elaborated in the report to be published, in the minutes to be published online. The panel also considered item 6.4, development applications greater than 180 days to be reported to the WLPP. And the panel noted that determinations have been made on long-standing applications and that further progress is being made. That concludes the deliberations and determinations of the panel. I'd like to thank my fellow panel members and the council staff for their assistance today, and I declare the meeting closed at 4:28 p.m.